The proceeding was about the summary of the employment-based preferences that are available for people who want to become permanent residents through their job skills. You should also be aware of the procedure the law requires us to follow. With the exception of the employment-based first preference, which I won't talk about in this video, it's normally required that the employer, the American employer, obtain a labor certification application before the employment-based preference petition, also known as an I-140 petition, can be filed. The labor certification process is sort of an intricate process laid out in the Department of Labor regulations. It basically requires an employer to demonstrate that they have actively recruited to find an American worker and that they do not discriminate against American workers. Well, what does that mean? Basically, it means that the employer is going to be paying prevailing wage, which is determined by Department of Labor statistics and other sources that we have available to us, and that they have done certain types of activities that are set up in the Department of Labor regulations to find qualified American workers. For instance, for pretty much all occupations, an ad has to be placed in a Sunday newspaper of general circulation. In addition, there are other types of recruitment activities such as internet searches and in-house searches, internet website, home business proprietary website job search, and other types of activities that are set up in the law that the employer has to go through before the labor certification can be submitted. In addition, the employer has to show that any applicants to these advertisements are not minimally qualified. That means that they don't possess the minimum education requirements or experience requirements set up in the job offer, which, remember, cannot discriminate against American workers. So it isn't that our client is better qualified than all the other applicants. It's that all the other applicants do not have the minimum qualifications. Now, as a result, how you set up the job offer becomes very important because obviously you can't have unusual requirements like speaking a foreign language unless it's absolutely necessary for that position, a business necessity. Additionally, if you're requiring advanced degrees, usually the positions that require advanced degrees have higher wages and salaries, which of course makes them more attractive to people who might be applying to these jobs. So it's a fine balancing act based on the actual discussions with the employer as to what the job entails and what the normal requirements are for that particular employer, and also what is normally required in the industry. Once we figure out these minimum requirements, we're stuck with them for the rest of the case. And the trick with these employment-based cases is you have to have it right in the beginning for it to work at the end. In other words, if you require a master's degree, you might get the labor certification approved, but if your client doesn't have the equivalent of a U.S. master's degree at the time the application was filed, then the petition won't be approved. Well, let's say you get through the labor certification process and the labor certification is granted, which, by the way, can take several months after it's submitted. Once the labor certification is approved, the next step is to file an employment-based petition, the so-called I-140 petition. This has to be done within 6 months of the approval of the labor certification. Usually there are not very many issues involved in the I-140 petition. Basically, you have to show that the alien, the beneficiary, qualifies for the job, that he has the necessary experience and education as set out in the job description that was originally used in the labor certification. And secondly, you have to show that the employer has the ability to pay that salary. Oftentimes, small employers either don't make enough money to show that they have enough revenue to pay for an alien or a new worker at that salary level, or they don't have the paperwork to document it, such as tax returns and so forth. My general rule is that an employer, that we'd like to have employers who have at least 5 employees to have them be a good choice to be an employer to sponsor you for a green card based on employment. Another thing you have to consider is the fact that because it does take a long time to go from the labor certification filing to when a quota number is available, especially under the employment-based third preference for skilled and workers, skilled and professional workers, that you're stuck with that employer for what might be several years until quota numbers become available. So you have to choose your sponsoring employer very carefully. Once the I-140 petition has been approved, the next step is just to wait until a visa number becomes available for that preference category. As I mentioned, the employment-based second preference, usually the quota numbers are available, except for people born in India and China. However, for the employment-based third preference, there can be a wait of several years. So it's very important to choose the employer who's going to sponsor you carefully, because you're going to be basically stuck with that employer for several years if you're applying under the employment-based third preference for a skilled or professional level, that's bachelor degree professional level, preference. Once a quota number does become available, which can be determined by the visa bulletin published by the Department of State, the applicant, the beneficiary, you, can file an application for adjustment of status, provided that you're still legally in the United States. The advantage of this is that not only can the principal, the person who the labor certification was filed on for, qualify to file the adjustment application, but the applicant's husband or wife and any unmarried children under 21 can also be included. By filing the adjustment of status application, so-called I-485, a person is entitled to get employment authorization and a travel document, and hopefully within a few months the adjustment application will be approved and the person will be issued a green card. There are occasions when CIS interviews the applicants. Usually the issue there is whether the person came legally and maintained legal status. Sometimes it also deals with the employer's ability to pay and the alien skills. Remember, usually by the time that this interview occurs, there's been a long period of time since the labor certification was filed, and in that period economic conditions may have changed, the employer might have gone out of business, other things may have changed as well. Fortunately, once the adjustment of status application has been filed, the aliens allowed to change after it's been pending 180 days, the applicants allowed to change jobs and get a new sponsor who can be substituted in for the sponsor who filed a labor certification application. Unfortunately, this can only be done at the time that the adjustment, after the adjustment of status application has been filed. If it's before that time, a new application, labor cert, has to be filed, and I-140 petition, although the applicant can keep the prior priority date, keeps his place in line. As you can see, employment-based green card processing is quite complicated. I've just gone over the basic points in this video. However, if you have any questions, please feel free to give me a call. My number is 818-788-8900. It's on the website, and I'd be happy to answer any of your questions free of charge.